The Leader of the Opposition.
Thank you, Mr Chair, and that understanding is correct as to the relationship between the two sets of amendments. I move Opposition Amendment number 1, standing on sheet C2016-019 capital D. This addresses the concern raised by the opposition during the second reading debate about what happens to customers generating rooftop solar post the closure of the solar bonus scheme. There is a view being promulgated in the industry that those persons who do not have smart meters installed will somehow not be able to access any return or an adequate or the best return for the rooftop solar they are generating and passing back into the grid. And it's to make the point that in fact the retail industry currently possesses all of the information needed to continue to provide people who do generate rooftop solar or indeed electricity from other sources with a return for that investment. Smart meters, although obviously conferring great benefits on retailers and on the network as a whole, and no doubt greatly to be desired by the Australian energy market operator, and as I also indicated in my second reading contribution, potentially conferring benefits on customers as well, customers should not feel in any way coerced or obliged to take this step. It's not, strictly speaking, necessary. The retailers have the information they already need to be able to work out whether or not to pay persons with rooftop solar anything post the closure of the solar bonus scheme, that is whether or not people are a net contributor or a net drawer on the electricity network. As I indicated, my energy company knows how much electricity I generate because they pay me for it, so they've already got that information. The electricity companies through the meter can already know how much my household consumes, therefore they know whether I'm a net contributor or a net drawer on the electricity system. And so post the closure of the solar bonus scheme, my retailer will know whether or not to pay me anything. But the concern we've got is that there is a view that has been promulgated that people do need to have smart meters to be able to continue to receive any return. And we note that, of course, the retailers are not, strictly speaking, legally obliged to provide a reasonable tariff for those who sell excess energy back to the grid. That the electricity companies are not currently obliged to pay anything for the energy generated by householders, which electricity retailers can then sell on to other consumers. Although we know there is an IPART recommendation, and we do note that retailers do voluntarily or are voluntarily indicating that they will pay something, but we also think, as we took to the election last year, that there should be a stronger IPART mandate to set a minimum price for rooftop solar so that people can get a fair minimum payment for energy fed back to the grid from those households generating solar energy. However, that will have to wait until the next Labor government or until the government currently in power decides that this is a fair and reasonable course of action. We do press amendment number 1. To the extent that retailers are already going to do this, it won't provide any impost on retailers. But to the extent that some retailers may not be going to take this path, we think some legislative guidance needs to be laid down so that customers who do generate rooftop solar do continue to get some return for that investment. Now, I note also that what is now called the Australian Energy Council, formerly the Retailers Association, has made a submission to the government about the legislation, and they approved the legislation in its current form in principle. And I have also had some discussions and interaction with that body, and I note that they are not in favour of this amendment. That's no surprise. The retailers feel that the current market and regulatory settings are adequate. We simply beg to differ. We say that, look, we accept that most of the responsible retailers would take a responsible course of action and would continue to pay persons or households generating rooftop solar a return. but we think legislative guidance is required because we do not want people to be coerced into having expensive new smart meters installed in their home unnecessarily. Many of the meters in people's households do not need to be replaced for any other reason. And I've even received feedback from people who already have smart meters, or so-called smart meters, but who are being told by their retailer that they're not sufficiently smart and that those meters would need to be upgraded yet again if they're to continue to, if they're to take the best advantage in terms of the return they would get on their rooftop solar generation post the closure of the solar bonus scheme. The retailers have all the information to be able to do this properly, and we think it appropriate that this Parliament give them the certainty and guidance in the form of this amendment, and also to provide consumer protection to not just the 160,000 households that participated in the solar bonus scheme, but all those other households who both before that scheme and since that scheme have decided to make a contribution to our shared clean energy future by installing rooftop solar and to participate in generating electricity. Thank you, Mr. Chair. Mr. Chair, these amendments are directed to page 3 of the bill and to the proposed section 31 capital A dealing with accredited service providers. Now, the government in its second reading speech indicated that at the moment accredited service providers level 2 and above are required, people are required to have that accreditation to do the installation work on meters, and the government indicated that they wish to create a wider market for the provision of these services by providing that other qualified electricians other than ASP level 2s and above could perform this work. And the government said that those performing the work would still have to be accredited to Australian and New Zealand standards, and that the government, I noted in the reply speech, indicated that the government didn't propose any sort of lesser standards. But at the moment, as we understand the national electricity rules and the current requirements of that level of accreditation by those installing the meters are necessary both to be sure about the skill of those performing the work and also to guarantee worker safety, but also the safety of the public and households. I note that the National Electrical and Communications Association made a submission on the rollout of smart meters in New South Wales on the 19th of February 2016, and they indicated that metering work has the potential for serious specific dangers, including electrocution and arc blasts, which have the potential to not only cause serious injury to the workers themselves, but to householders and members of the public, for example, through house fires. And that's on page 9, and that proposition is elaborated in some significant detail to lead to the conclusion, in the view of that industry association, that the current situation should prevail. That is, in order to install these meters, the requirement for that work to be restricted to ASP level 2s and above should be maintained. Now, the government, in its speeches, has suggested that there should be a different standard, but they haven't really indicated what that standard will be or how that addresses the concerns outlined both by NECA and by the Electrical Trades Union and by others about if you allow other qualified electricians without that accreditation, how do you ensure worker safety and safety for householders and the general public? And we think that is a significant concern, It's a concern that is given rise to by proposed Section 31 capital A to be placed into the Electricity Supply Act. We don't want any tragic events to unfold in the days, weeks and months to come simply because of the government's desire to roll out or have the potential for smart meters to be rolled out in New South Wales. As desirable as that may be for some, we think the group of amendments that we've proposed, including the one that was just unsuccessful, would actually secure a situation where there wasn't the need for a rushed mass rollout. It could be done in a more orderly and staged fashion. But notwithstanding the lack of success of that first amendment, we still think these two amendments are necessary. The second amendment removes 31 capital A subsection 2, which provides that the regulations may exempt the provision of specified or a specified class of contestable network services from the requirement. The services must be provided by an accredited service provider. We think this is the mechanism the government will use to reach its approach. But again, we want to know in advance, before we signed off on this, what those exemptions would be, exactly who would be permitted to do this work if it's not to be restricted, as it is at present, to ASP level 2s and above. So we ask the government to be frank with us, be frank with the Parliament and the community about exactly what its plans are. I know sometimes legislation is passed which is facilitative, and therefore in days and weeks to come there are regulations or other documents provided that flesh that out, and I understand this is one of those provisions, but we think the potential hazards to those performing the work and householders and the general public is such that this is something that really needs to be resolved with clarity at the legislative stage rather than down the track. And we are very concerned about this, and we ask that the government be very clear about what it is proposing and how it proposes to do this in a way that ensures safety for all concerned. So we do urge amendments numbers 2 and 3 on the House and ask honourable members to join with us in support. Mr Chair, the government seems to be trying to have it both ways. On the one hand, they're saying, look, don't worry, there'll be no change. Only accredited service providers will be able to do live work, and so there'll be no substantive change in this area, which of course is the precise object of the opposition's two amendments. But despite this, the government says, well, the opposition's amendments will create problems. So they really can't have it both ways. Either they propose to change the current situation, where only accredited service provider level 2 or above can actually do this work, or they don't. And if they don't propose any change, then there's absolutely no problem for the government in embracing the opposition amendments, to put that beyond any doubt, and to allay any concerns that may exist in the industry or in the wider public. The fact that the government is not willing to embrace our amendments suggests that, despite the words of the Parliamentary Secretary, the government does have a plan to have different and lower standards for those performing this work. It's important to note that, with the exception of ASP level 2s, electricians in New South Wales have never installed electricity meters. To ask electricians to undertake this kind of work without proper training and accreditation could risk serious injury or death. Now, I mentioned two potential risks, arc blast incidents and transpositioning. An arc blast develops during and following an electrical fault and results in the ignition of oxygen surrounding an installation or a plasma cloud. It's characterised by temperatures in excess of 15,000 degrees Celsius, a cocktail of superheated toxic gases and airborne molten metal from melted conductors and steel released by the components within an electrical assembly fault. It can result in a rapid energy release with a pressure wave developing of significant magnitude, and if a person is standing in front of an installation during an incident, a plasma cloud will envelop the person. Obviously, a serious arc flash incident has the potential for loss of life and property damage. Transpositioning is an electrocution shock hazard and occurs when there is interposed wiring where the active and neutral are switched. practical outcome of this mishap could be metallic gas and water pipes reinforcing in concrete showerheads and the water that comes out of showerheads, and every metallic appliance in the house could become live as a result of transpositioning. Electric shock or electrocution will occur when a person comes into contact with any of the above, and of course it's stating the obvious that that could also result in a serious injury or loss of life. Now, our two very reasonable practical amendments are to ensure that there is no dilution of the current safety regime or the level of skill and accreditation required by those who perform this work. And the government says, look, don't worry, that won't change. But they seem to be fencing with words, because they say, well, there'll be no change in relation to who can perform the live work. So they seem to be drawing a distinction between the live work and the rest of the work surrounding the installation of the meters. And the idea of being able to parcel out the work in that way, I think, is misleading. If the government really intends there to be no change as to who performs this work and the resultant security and the resultant maintenance of standards in this area, the government will embrace the opposition amendments. If they don't embrace the opposition amendments, it means the government intends, through the regulation power they will get under Section 31 capital A, to have a different and lesser regime of accredited professionals performing this work, and that gives rise to the very significant safety concerns that we have raised, safety concerns for householders and the wider public, but also safety concerns for the individuals who are performing this work. Obviously, with a significant body of persons, up to 160,000 of the solar bonus scheme alone, who may, a significant proportion of whom may wish to change to advanced meters, will create potentially a demand for work. And it may be that a number of electricians, qualified electricians, will want to participate in that market, not unreasonably. But if they don't have the proper level of training and skills, what the government would be creating is a potential recipe for disaster and tragedy unless careful safeguards are put in place. The opposition proposes in a constructive way those very safeguards, and we urge the government, and if not the government, the other honourable members in this chamber, to join with us and to put public safety first. Thank you, Mr. Chair. This amendment seeks to protect consumers from being charged for the installation of advanced meters. As I indicated in my second reading contribution, it may well be the case that retailers will offer advanced meters to their customers, both new and prospective, without charge, but there is a risk that, combined with the closure of the solar bonus scheme, combined with this notion that people with rooftop solar need a smart meter to continue to benefit to any degree in connection with the electricity they generate from their rooftop, that they will feel coerced directly or indirectly into having smart meters when otherwise they would not need them. And we are concerned that those customers, or a good proportion of them, may be exposed to significant additional costs which are not necessary. And so this amendment is a consumer protection measure to protect consumers from that additional expense. As I indicated, we accept that one or more, maybe many of the retailers will do this for their customers free of charge, but maybe others won't. And there is difficulties, given the complexity of different offerings from different retailers, for many customers to make informed decisions about what best suits them, given their place in the life cycle and their energy consumption pattern. So we think this is an important consumer protection measure to put the matter beyond any doubt, to allay any concerns that may exist that persons, households with rooftop solar will unnecessarily have to switch to having advanced meters. So I urge honourable members to support this amendment.
Mr. Deputy President.